is essentially a continuation from the previous chapter. The previous chapter where we discussed the iddah and ahkam and iddah, yeah, the waiting period for the woman, and that within that discussion, we mentioned the rulings within that, and with this particular chapter today, we have the bab al-Iḥdād, where the Iḥdād is in reference to the iddah of the widow, in the iddah of the woman whose husband has passed away, in her waiting period. So essentially, even though it's not directly linked to a talaq in terms of the ahkam of the divorce specifically, the link is found due to the fact that it still requires an iddah. If the husband of the woman passes away, then it requires an iddah. And we discussed this, we touched upon it briefly last week when it came to this particular topic, where we were discussing a speech of Shaykh raḥimahumallāh, and we were discussing some of the wisdoms or asbab and some of the reasons why the iddah is present. And from those asbab, from those reasons mentioned, is that it's idhar, in the idhar of huzn al-zawj, that the huzn al-zawja, that the woman, she presents and she makes apparent her grief, the grief for the death of her husband. And of course, this is referring to the woman whose husband has passed away, and that's what we wish to discuss today. And so the author raḥimahullah, he mentioned beginning وهو واجب, regarding al-Iḥdād, the iddah for the widow, وهو واجب على المتوفى عنها زوجها وهو اجتناب الزينة والطيب والكحل نعم وإثمد ولبس الثياب المصبوغة لتحسين. And so, relation to Iḥdād, then it's referring to the ruling of the woman whose husband has passed away, and upon her is to leave off particular things. And from the ahkam, from the rulings found, is that she has to make luzum al-bayt. So she must remain within the home and stay away from perfuming herself and wearing the clothes of zina, beautifying herself, or wearing clothes that are essentially the best clothing that she has. Likewise, from what is inclusive of that, is that she avoids wearing jewelry and the likes of that. And this is essentially in accordance with the ahkam of the iddah as well. So we mentioned some of the ahkam of the iddah previously. Now, the same ahkam, the same rulings apply. And so the author, where he mentions it, he mentions it's wajib that the woman, she avoids the perfuming and beautification, wearing the kuhl, and as well as wearing her best of her clothing. So here, barakallahu feekum, the author is mentioning these things, that she stays away from perfuming herself, or the wearing of, for example, bukhur and the likes of that. What we know that the perfuming for the woman is generally muharram. That's muharram. And that the perfuming is essentially a woman going out wearing the perfume is from the expression of tabarruj. The woman making tabarruj and exiting the home, express it with the expression with more than that is of what is permissible. So with that being said, why is the mention in here of she's not allowed to wear the perfume or wear her best clothes or wear her jewelry? Why is that being mentioned here by the author, raḥimahullah? So what's he referring to though? Because the general ruling is haram anyway. Sah? No. In the Naam. So what the author here is referring to specifically is in the home. The asl of the ruling, obviously, of course, is that she can't go out and do this outside the home, whether she's the widow or not. So when the author, raḥimahullah, is referring to the fact that she cannot do these things, not referring to the fact of outside the home. This is muharram anyway. Within the home, it's a matter which is the asl of the ruling is within the home, woman is allowed to do this. Rather, if she was married, then it's something from the obligations for her to do. So within the home. However, this particular ruling here, in terms of this scenario she finds herself in, if she's in the ዒدdah, then this particular ruling becomes one where it is not permissible for her to do. Now, so she exits from the asl. The asl being that she was permitted to do it. Now she's not. Now she's permitted to do it, and now she's not. And so, when it's referring to the fact that she must avoid these different forms of perfuming, then this is now all the different forms of perfuming. So whether that be the bukhur, whether that be the liquid perfume, any form of perfume, anything that is used essentially for its scent, then she should avoid it. Likewise, she avoids any form of beautification. That beautification occurring, whether that beautification occurs from wearing of jewelry, or that beautification occurs from wearing of the malabis zina, in the clothes of beautification. Likewise, she avoids wearing the clothes of or putting on the kuhl as well. She avoids wearing these things, as this is not permissible for her in that state. The one whose husband has passed away. And this is due to the statement of the Nabi alayhi salatu wasalam, the hadith. Due to the hadith of the Nabi alayhi salatu wasalam, which is found in Bukhari and Muslim, متفق عليه, where he mentions لا يحل لامرأة تؤمن بالله واليوم الآخر أن تحد على ميت فوق الثلاث إلا على زوج 4 أشهر وعشرا. 4 أشهر وعشرا. And so the Nabi alayhi salatu wasalam, he mentions in this narration, it's not permissible for a woman that believes in Allah on the last day to mourn the dead for longer than 3, except for the wife that she mourns for 4 months and 10. So this narration here, barakallahu feekum, قوله صلى الله عليه وسلم, his statement صلى الله عليه وسلم, he mentions the number 3. The number 3 is referring to what, barakallahu feekum? 3 days now. So the mourning period and the period of grieving is of 3 days, and it shouldn't be exceeded. So the 3-day period should not be exceeded. Thereafter, the narration mentions the exception to that. So as you find with these, with it being directly from the narration, or whether it's from the ahkam that I mentioned from Ahl al-Ilm wal Fuqaha, you find that there are rulings, and you have the asl hukum. You have the asl hukum, the foundational ruling. And then after that, you may have rulings that derive from that asl, or rulings that are exceptions to that asl. So as we mentioned earlier, the asl for the woman is that it's permissible for her to beautify within the home, except for this scenario that we're mentioning here, in fi halati hadi, in this particular hala, in this particular scenario that she finds herself in, she cannot beautify herself when she is the widow. For that ዒدdah period. Likewise, we have the ruling for the grieving, that the grieving should not exceed 3 days. So that is the asl ruling. As it was mentioned in this narration, in the Messenger of Allah sallallahu alaihi wasallam, he mentions, however, the istithna. He mentions the exception to that ruling, and the exception to that ruling is for the widow, where she grieves for the period of 4 months and 10 days. 4 months and 10 days. And this Iḥdād, this particular ዒدdah for the grieving woman, its hukum is يعني واجب. نعم. The hukum is wajib. So we have, when it comes to the grieving, the ahkam, you have ahkam which are wajib, and you have ahkam which are mubah. As for the wajib, when it comes to the grieving, then the wajib for the grieving is the wajib upon the widow. This is the obligation. It's the obligation upon her to grieve, and grieve for the period of 4 months and 10 days. Then you have that which is mubah, that which is permitted. And what is mubah is the period of 3 days, and this is for anyone else that seeks to grieve for the deceased. Anyone else that seeks to grieve for the deceased. But they cannot exceed those 3 days as mentioned. Naam. Likewise as well, the author goes on to say, وَعَلَيْهَا الْمُبِيدُ فِي مَنْزِلِهَا الَّذِي وَجَبَتْ عَلَيْهَا الْعِدَّةُ وَهِيَ سَاكِنَةٌ فِيهِ إِذَا أَمْكَنَهَا ذَلِكَ. And after the author mentions upon her is to remain within her home. Naam, she's meant to remain within her home and stay within that home. And this is essentially the home where she received it, or she became known to her that her husband had passed away. So she stays within that home. As the author mentions, in amkana dhalik. إذا amkana dhalik. If this is possible. Now, it's possible for her to do so. So she stays within the home in which the husband had passed away. Now, so if it's possible, then she stays. And so, of course, this is referring to a scenario where, if now, for example, the home was directly attached to the husband, so the home is lost with his death, then this would not be something which is possible for her to stay. So then in this scenario, she, whatever abode she goes to after that, then she stays in that abode, and then she fulfills all of the ahkam of the iddah in that abode. So what we understand from this is that the iddah itself, or the iḥdād of the zawj, now this period of mourning for the zawj, is not the period of mourning for the zawj is not restricted to a particular abode. Now, it's not restricted to a particular abode. So it's not, for example, now, as long, we won't say, for example, as long as she's within the home of her husband, then she has to adhere to the ahkam of the mourning, the ahkam of the grieving. No. If, for whatever reason, the asl of the hukum is that she stays in that home. If, for whatever reason, she's not able to adhere to that particular asl, then she can stay within another home, but then adhere to those particular rulings. Naam. Naam. Also, the author mentions as well, فإن خرجت لسفر أو حج فتوفي زوجها وهي قريبة رجعت لتعتد في بيتها. And so, in the scenario that she's traveling, or she's performing Hajj, and then her husband passes away, while she's still close, to home, then she she returns to the home and begins her iddah. She returns to the home and begins her iddah at that point. And so, if she is close and it's for example short distance, then it's an obligation upon her to return. It's an obligation upon her to return. Now, what could be understood from this as well is the qurb, her being close, is the illah in that, what is understood from that is not necessarily just the proximity from our home, the close proximity from our home. However, that close distance being that she has the ability with some degree of ease to return back. She has the ability with some degree of ease to return back. So now, in the days that we live in, that ability to return back with ease is one which is possible for many. Now, due to the existence of airplanes, where if, for example, a person travels to one place or another, it's not necessarily attached to its distance or how close it is. Now, just due to the existence of the different wasail, different means of transport. So, for example, the means of transport. For example, if I was to drive to London, even though it's much closer, that drive in that same amount of time, a person could board a plane and be in Morocco or even further. So a whole other continent. And so with that being understood, that ease is found within both things. That ease can be found in both things. So it's not necessarily an issue of al-masafa, an issue of distance per se. Now, when author raḥimahullah mentions distance, he's mentioned distance specifically due to the fact that when discussing distance at that time, distance would be attached to ease of return. Distance would be a direct factor in terms of ease of return. However, if now, for example, the distance is quite far, so even if we factor in this issue of the existence of airplanes and the likes of that, her returning is one which is not one of ease. So, for example, she's traveled, but she lives here in the UK, but she's traveled now to somewhere further away in Asia. Now, for example, Indonesia. Now, in that example, it could be stated, and it could be argued in her hal, in that particular scenario that she finds herself in, she is not able to travel with ease and return with ease. So she may find it may be stated that she may conclude whatever she was planning to do, and then return at the time that she initially planned to return. Allah Ta'ala knows best. Now, however, the author goes on to say, وَإِن تَبَاعَدَتْ يعني مضت في سفرها. And so if now, however, she has found herself in a far distance, as we mentioned, distance referring to صعوبة, difficulty. So if she finds herself in a scenario where it's difficult for her to return, then she may remain within that safar. However, she makes iltizam بأحكام العدة. So she seeks to adhere to those rulings of the iddah itself. She seeks to adhere to those rulings of the iddah. And the ruling with this is the same ruling in terms of the iddah of the woman whose husband had divorced her 3 times. So the talaq, which is ba'in. And doesn't have the ability to return. So she leaves off everything from these things we mentioned in terms of the beautification and the likes of that. And Allah Tabarak wa Ta'ala knows best. And that concludes what we wanted to discuss from this particular chapter of the Iḥdād. After that, we have the chapter of al-nafaka of the mu'taddat. So the nafaqa in relation to the payment that is given and the provisions that are given for the woman within the iddah. The woman within the iddah. And the author, raḥimahullah, mentions وَهِيَ ثَلَاثَةُ الْأَقْسَامِ. It's made up of 3 categories. أحدها رجعية. يعني the first of those categories of the woman in her iddah, so there's three categories of women in iddah. The first category is the raj'iyya. The first category is the raj'iyya. The raj'iyya, she is the one ما يمكن زوجها إمساكها فلها نفقة وسكنى. So this is the first one. نعم, is where she can be taken back. She can be taken back. So if she can be taken back, then which talaq are we referring to then? First or second, of course. Now, so if the man has divorced the wife for the first time, or divorced the wife for the second time, then there's the possibility of taking her back. Then in this scenario, the author he mentions that the zawj, the husband, the zawj has to yani, spend upon her in terms of her provisions and give her the sukna. Yani essentially establish and provide for her accommodation. When we say provide accommodation, what is that referring to? Paying the rent. But where? His home. Now, I'm going back to the point we mentioned previously, that when it comes to the iddah period is observed within his home. That the two spouses, they live together, they live with one another within the home. And it's not, as you see, Allahu musta'an, on many occasions, as soon as a divorce is pronounced, that they split, and the woman either she goes back to her own home, or the man leaves that home, leaves the marital home. Now, what is upon him is that he preserves his wife, preserves his wife in the home, and he observes it in the period whilst they both live there. In relation to the topic at hand, in terms of the spending and in terms of him spending upon her, then upon him is to spend upon her as well. Now, then the author mentions as well after that, ولو أسلمت امرأة الكافر أو ارتد الزوج المسلمة بعد الدخول فلهما نفقة العدة. And so in this scenario where the wife of a kafir, she embraces Islam, or the husband of the Muslim woman, apostates, leaves Islam after dukhul. So after the marriage has been consummated, then in both of these scenarios, the woman is entitled to the iddah. The woman is entitled to the iddah. To the nafaqah and iddah, sorry. So what's the first scenario mentioned there? Nah, so the woman becomes a Muslim. So they're both kuffar. The woman becomes a Muslim, the husband doesn't. Now that's the first scenario. The second, the one where they were both Muslims, but then the husband apostates. What's the commonality between the two? The woman's a Muslim and the man is kafir. Naam. And so what did we mention previously about this scenario? If the woman's Muslim, the man's a kafir? Naam. That's something that nullifies the marriage. Nullifies the marriage. And so that's what we mentioned previously, that this is a case that nullifies the marriage. But then with that being said, now, if that nullifies the marriage, what's the hukum when it comes to the iddah? Because it's still the iddah. Naam. Because when we look again at some of the reasons for the iddah and some of the wisdoms found with the iddah, then what is mentioned or what are the reasons for that still exist. As the reasons that are the reasons that we have this iddah, they still exist. For what example? Now, to make sure that the woman is not carrying a child, any pregnant. What else? That nikah has any to bring absolute end to the nikah, and something else as well. It could be that as well, but also something into the first reason. Taz to yani preserve the lineage as well, preservation of lineage, to remove any form of yani confusion of lineage. So, and so there's just irrespective of whether one individual has embraced Islam or one individual has left Islam, these reasons still exist. Now, these reasons still exist, and the lineage still needs to be preserved. And the likes of that. So, after the author goes on to mention نعم الثاني, the second, so the first is we mentioned the first type, which is the wife that can be taken back. The second, الثاني البائن في الحياة بالطلاق أو فسخ. So the second is the ba'in. So this is the irrevocable divorce. So the woman that is in a divorce is irrevocable divorce. نعم. طيب نعم. فلا سكن لها بحال ولها نفقة إن كانت حاملا وإلا فلا. And so the author he mentions يعني البائن في الحياة بالطلاق أو فسخ. So the divorce comes about and is irrevocable. So essentially, divorce is established by way of talaq. That's the first thing mentioned. It's irrevocable by way of talaq. So talaq we're referring to what exactly? The third, but how is it established? The man giving the divorce, the talaq. So essentially, because we're going to after this, we're going to mention different forms of after today's lesson. So the next few lessons, we're going to mention different forms of ending of the marriage. We mentioned previously the khula'. We're going to mention other forms. So it's important to understand specific terminologies, because when we mention talaq can sometimes be understood as generally the ending of the marriage. But if we're talking about talaq, yani, with its and its specific terminology and specific istilah, yani, and its ta'rif in terms of the shar', in terms of the sharia, its definition in terms of the sharia, then the talaq is referring to the husband issuing it. Now, the husband issuing it. So in this case, it's referring to now that the marriage is irrevocable due to the talaq as one reason, or yani, the marriage is irrevocable due to what is referred to as fasq. The marriage is irrevocable due to what is referred to as fasq, yani the nullification of the marriage. Now that the marriage is nullified. And so with that being said, if the marriage is nullified, then referring to who? Who nullifies the marriage? Naam, the Qadi. So we're talking about the nullifying of the marriage and rendering that marriage void. Then this is in relation to a case being brought before a judge, and then the judge, yani, ruling that based upon all of the information being given, that marriage has been brought to an end, is nullified. But what we're referring to here is that the marriage is nullified to the extent that it's nullified irrevocably. The marriage is nullified irrevocably. And so, with that being said, in that particular scenario, I saw that the woman is in a scenario where she's in an irrevocable divorce. Then she does not have any sukna, so she's not given any abode. She doesn't live within the home. No, she doesn't live within the home. Why does she live within the home? She can't return. No, she can't return. And so and how does that relate to some of the goals of the iddah itself? Question make sense? No.
There's no way that she can beautify herself if it's not beautiful.
She can't beautify herself. What? No, I'm saying she can't. What about in relation to the goals, though? The goals of it. Can't marry again. So then, no, can't marry again. So they can't get back together. So what does that mean? Essentially, the answer's here, and you're like, no. Essentially correct, but no. They can't have relations. Sahih? No. They can't stay in the same house, of course. That's Sahih. But what do we mention? What are some of the goals of? If we go back to again to the goals that we mentioned from the Kalam of Shaykh raḥimahumallāh, what are some of the goals of the Iḥdād? What are some of the the reasons and the wisdom behind the Iḥdād itself? To create reconciliation and to ensure what? Nah, that the decision is emphasized essentially, because now that decision to not reconcile, they know for sure, because it's not now based upon al-lahza. It's not based upon a moment of emotion. It's not based upon a decision that's made without any form of thinking, without time. And so, with that being said, that's from the reasons that you have the Iḥdād, because now if you have that Iḥdād period and still after that the person makes that decision that they're going to end the marriage, and you know that there, to some degree there's some certainty found within that the person has certainty based upon if the person, of course, has respect for the ahkam and respect for himself and the wife, he's going to do his due diligence within that time as well. Now, and both parties do their due diligence in that time in terms of adhering to the Sharia, seeking to reconcile within that time, or take the means to reconcile within that time, seeking to find the help, seeking to find any solutions for whatever issues that they're facing. Now, all of that is within the Iḥdād. So, if after all of that they can't come to a conclusion, then you know that this is for sure a better scenario for them. Allah Ta'ala knows best, or one which has a degree of there's some degree of thought found within it. And according with that, all of that being said, though, if now the talaq is irrevocable, then there's no opportunity for that anyway. If the talaq is irrevocable, then there is no opportunity to try and reconcile, try to come to common ground, try to re-establish whatever has caused that divorce to be given in the first place, because it's irrevocable. So the woman has to leave that husband eventually anyway. And so if the woman is required shar'an to leave the husband, then of course there's no need for her to stay within the home. All other things mentioned by the ikhwah, exactly, of course, are correct as well. Now, they cannot have relations, that they cannot take her back. Now, but the whole from the goals and the reasons behind it that cannot be established in this case. So if that cannot be established, then of course it's not upon him that the husband, provides her with a home. No, provides her with a home. And likewise as well, the nafaqa is not given. Nafaqa is not given. So the provisions, the man does not pay for her if the divorce is one which is irrevocable. Now, in kanat حاملا, in kanat حاملا, so if she's pregnant, then she is permitted to have that nafaqa. And if she's not, then no, she's not. So if she's pregnant, then the husband pays for her. So with that, we understand that there's a difference between the two. So we distinguish between the two, between providing accommodation and paying for the wife. Providing accommodation, paying for the wife. They're not the same. So in the second scenario, they do not pay for the wife. He doesn't accommodate for her at all, whether she's pregnant or not. In the second scenario, he doesn't pay for her if she's not pregnant. If she is pregnant, then she pays for her. Naam. If she is pregnant, then he pays for her. So, and why does he pay for her? No. No, essentially for the child, for the nutrition of the child. So he's paying essentially to aid her with that scenario. And we understand that because what? The nafaqah continues if she was pregnant while she's breastfeeding as well. So the nafaqah will continue to a particular extent if she was still breastfeeding. Now, is that clear, barakallah fikum? Now, so this is the second. Then we have the third. Now, the third, التي توفي عنها زوجها فلا نفقة لها ولا سكنى. And so the third is the one whose the one whose husband has passed away. Whose husband has passed away, and going back to what we mentioned previously, the widow. And in this scenario, then there is no nafaqa, wala sukna. So there's no payment that's given to her, nor is there any accommodation afforded to her. No payment given to her, nor is there any accommodation afforded to her. So, and what she suffices with is what? What she suffices with is the mirath. Now, what she suffices with is the mirath. Now, because of course she was the wife of that particular man, and so she inherits from him. Now, and this is the transference of the wealth. This is how the wealth transfers. As for any form of accommodation, then of course the scenario is quite obvious as to why he cannot provide the accommodation. He can't provide accommodation or wealth, and all she does, as mentioned, all she does rely upon, or all she is afforded, is that inheritance, which is essentially established by way of the Sharia. And Allah subhanahu wa ta'ala knows best. And with that, we will conclude what we want to discuss from these chapters. The next chapter, Istibra al-Ima, the releasing of the slaves. I believe this chapter will skip it because, as I say on many occasions, slaves, no one really has slaves in Manchester. So the ahkam, what the goal behind these lessons is to try and really study the ahkam that are relevant to us, and whether it's the case of the ahkam of nikah, where the person is seeking to marry, for example, or the ahkam of buyu', where the person may get into business dealings and need to understand, or the ahkam of talaq, where inshallah the person understands that ahkam of talaq so that they can avoid this particular matter. Then this is why we try to go through some of these durus and benefit one another. Barakallahu fikum. So with that being said, what we'll do within the next lesson is go onto some of the other chapters, which are essentially subsidiary chapters of talaq, kitab al-talaq. So it's still attached to talaq, but they're not directly found within the chapter. So you got kitab al-dihar and kitab al-li'an. Now, kitab al-dihar, kitab al-li'an. Dihar, the person is stating that the person is like the back of the mother. Li'an, where the person curses or asks a curse upon the spouse, or likewise themselves. We'll discuss it in more detail once we come to it, inshaAllah ta'ala. فجزاكم الله خيرا وبارك الله فيكم وصلى الله وبارك على نبينا محمد وعلى آله وصحبه وسلم. نعم.
Is it different opinion regarding talaq, but if the husband still houses?
There is definitely some different speech regarding it. and that he's still responsible for her, even housing, not in relation to housing, because the housing she can no longer stay within the home. So if you understood the matter to be that the woman doesn't have a council house given in her name, so she just comes from her father's home, you know? And this is the asl, of course. She comes from the father's home, goes to the husband's home. Then in this scenario, when she divorces, she's no longer the wife of that man. So she can no longer stay within his home. No? I mentioned all the reasons why that occurs. So so then she goes back to where she was before, which would be the home of her previous wali, which is her husband, father, sorry. As for the second aspect, which is the nafaqa, which is the payment, then now there are different opinions in relation to that. The different opinions, revolve around the fact that she still can be regarded as being في ذمة الزوج كما يقال, within the essentially she's still regarded as being the wife to some degree of that man. Naam. And so if she's still the wife of that man, because she still some attachment to him, then he has to pay for her. But the reality is, as Kama ذكر Ibn Qudāmah, is that no, he doesn't pay for her. Why? Because in reality she's not the wife. Naam. And she doesn't have any of the ahkam of the wife anymore at that point, right? When it's irrevocable divorce. The only thing that remains is that she cannot remarry until she ends that iddah period to establish whether she is carrying a child or not. So because she hasn't carried any of the ahkam of the zawja in that point, then it cannot be said that she now is given the wealth. If you compare that now though to the woman that is divorced, however, she's divorced with a revocable divorce. Naam. So the raj'iyah, she's divorced maybe first or second time. She still has all of the ahkam of a wife. Naam. She still has to establish the rights of her husband. He still has to establish the rights of her. The only thing that's not established between the two of them is what? The marital relations. Everything else is still established. Naam. And so with that being said, of course, he still has to pay for it, and he still has to house her. So that's the clear difference between the two. And that's why that particular ruling is there, because there's an absolute clear distinction between the two. Now.
So did they say until the iddah period?
Those that say that he's still until the iddah period elapses, yeah. No, so until the iddah period elapses, then that's when he pays. No, but the reality is no.
So with regards to the irrevocable divorce,
Mhm.
and if she's carrying his child,
The irrevocable divorce and she's carrying his child, yes.
so with regards to nafqa, does that include, to what extent is that include paying for a place where to live if he has nowhere else to go?
No, so as you mentioned, so the nafaqa and the sukna are two things. So you have the accommodation, you have the nafaqa. With that as well, that as you mentioned, the difference of opinion regarding the first matter, there's a difference of opinion regarding this as well, where some of Ahlul Ilm, they state that the accommodation and the nafaqa have to both be given to the pregnant woman. Whilst others from Ibn Qudāmah, the author raḥimahullah, he says no, the accommodation is one thing, whilst the nafaqa is something else. The nafaqa for the payment for her is given if she's pregnant. As for her accommodation, and this is separate, and it's not given to her. Now, because at the same time, when we talk about accommodation doesn't necessarily mean wealth. Accommodation is the asset of the home itself, and so the reality is that the home is the husband is no longer responsible for housing her, even if now she has his children. He's no longer responsible for housing her now, because as we understand, going back to the asl is that she would go back to the home of her wali. Now, whether that be her father or anyone else from the awliya of the woman. So in that case, there is that clear distinction. There's that clear distinction. Allah knows best. Barakallah feekum. Hayakumullah, barakallah feekum. Naam. Salam to that.
When they're on suffer, the husband dies,
Hmm.
and he was the only one traveling with the wife.
So the husband was traveling with the wife, and then the husband dies.
The husband dies.
No.
And it's a matter. Can she return without a man? Can she return by herself?
So if the husband dies and they were both traveling together, The asl is that she cannot travel without the mahram. So should be a mahram that comes to bring her back to her home. However, if now, there's a degree of su'uba, the degree of difficulty, or even could be mentioned istihala, could be a degree of impossibility. Then it's not a case now. She says, "I'm just staying here." She's wanted to travel back, because this is now regarding the hal al-durura. This is now a necessity, and of course you have the statement of Allah Ta'ala, فَاتَّقُوا اللَّهَ مَا اسْتَطَعْتُمْ. Fear Allah as much as you're able. Or the statement of Allah Tabarak wa Ta'ala, لَا يُكَلِّفُ اللَّهُ نَفْسًا إِلَّا وُسْعَهَا. Allah Ta'ala is not burning a soul more than he can bear. And so Shaykh ʿUbayd, raḥimahullah, mentioned these two ayat on regular occasions when it comes to these particular masail, where of course you do as much as you can to adhere to the ahkam and the haqq. If for whatever reason now it's beyond your ability, or that it is something which is of severe difficulty, then of course the person fears Allah as much as able, and if you're not able to adhere to that, then they embark upon whatever action they need to do because of the durura, because of the necessity. Now,
when you say mourn for 3 days, what does mourning mean in that situation? Because you mentioned explicitly what it means for the widow.
No. So the mourning, generally you have given the condolences to the family members, and any specific action which is not mukhalif al-sunnah, but also it mentions anything to do with the remembrance of, or remembering that individual, or mentioning that individual, or anything specific linked to the death of that individual. It doesn't mean now you can't mention them after those days, but if you do anything specifically linked to the death of the individuals, for example, you go to the home of their families, give the condolences and the likes of that. Now, but you don't make that an event, because if you make that an event, then that's mukhalif al-sunnah. The Nabi alayhi salatu wasalam never did that. Now, so this is what's understood from that. Wallahu alam. So it's something which is general to some extent. نعم بارك الله فيكم جزاكم الله خير جزاكم الله يا إخوة جزاكم الله خير وصلى الله وبارك على نبينا محمد وعلى آله وصحبه وسلم بارك الله فيكم